Well, welcome all. It's a delight to have all of you here, even if virtually. My name is Lynn Brown. I'm a Senior Vice President at NYU and also Executive Director of the John Brademas Center. So welcome to Constitution Day 2020. And we're going to have for you this evening a very special performance and discussion that we hope you will find informative, engaging, and thought-provoking. So first of all, what is Constitution Day? So of course, as I'm sure all of you know, that is September 17th because it commemorates that day in 1787 where the delegates for the Constitutional Convention ratified the Constitution in Philadelphia. So we're not hitting Constitution Day exactly, but we think we're close enough. Since 2004, by congressional mandate, actually, all not-for-profit educational institutions, including colleges and universities, are to put on some programming in and around the Constitution. Now, under Tom McIntyre's adept leadership, NYU has never decided to do this in a boring or pro forma way. And so in our past Constitution Day commemorations have consisted of beat poetry competition, Thomas Jefferson impersonators, don't ask, and this year and the year before, a great partnership with the Verbatim Performance Lab. A word just about the Brademas Center. The center is housed at New York University, and it's named after former congressman and former president of NYU, John Brademas. The mission of the center is to engage with people and programming who care about the issues that animated John's life and devotion to public service. And those were education, culture, arts and humanities, global outreach, and the legislative process. So we particularly have as our hallmark at the Brademas Center that we want seasoned and civil debate at all times. And so we have pulled together just the right group to do that. So let me begin the introductions. Part of what I'm going to tell you is what we're going to see and who's going to bring you the show. We have, I think, just the right group of people, and we have just the right topic, I think. We're going to try to shed light today on what are the historic and continuing struggles for the most fundamental right of citizenship, the right to vote. And this is certainly a timely topic as we approach an historic election, and where access to the ballot has actually emerged as a key issue in that election. So the talent we are bringing to you this evening includes the Verbatim Performance Lab and its head, Joe Salvatore. Joe will explain exactly how the Performance Lab operates. Mainly they draw from documentary theater, verbatim performance, and ethnodrama to challenge our assumptions, to make us think and feel, and then to reflect. To help with that reflection, oh, and I must say, give the home of the Verbatim Performance Lab, which is our Steinhardt School of Culture, Education, and Human Development at NYU. And that is very important for me to add because the dean of that school is actually watching me right now. So to help with that reflection, we are going to enlist the aid of two leading scholars in this field. Professor Franita Tolson, and let me just look down so I make sure I get her bio correct. So she is Vice Dean and Professor of Law at USC's Gould School of Law. She's an expert on the Constitution, election law, legal history, employment discrimination. And a lot of her writings have focused on issues such as gerrymandering, political parties, the 14th and 15th Amendment, and the Voting Rights Act of 1965, which is one of the central dramas that we'll be bringing you today. Jack H. Knott is our newest NYU Dean of the Steinhardt School. He actually is an escapee from USC, where he was Dean of the Sol Price School of Public Policy. And his focus of interest has been the interrelationship and intersection of governance structures and the public policies that those structures produce. And then just a word of thanks to our co-sponsors before I conclude, which in addition to the Brademas Center, NYU Votes, the Birnbaum Women's Leadership Network, NYU Global Student Life, and NYU Steinhardt. So with that, take it away, Joe.
Great. Thank you so much, Lynn. I appreciate that very much. And thanks for having us again this year. We enjoyed it so much last year, so we're really happy to be back with you. So this project has its origins in a conversation that I had earlier this summer with a doctoral student in educational theater here at NYU. Her name is Tammy Swopes. Tammy had collaborated on projects in the Verbatim Performance Lab in the past with myself and our associate director, Keith Huff, specifically around a project that's called the Serena Williams Project, which looks at what happened to Serena Williams at the 2018 US Women's Open tennis final. In our conversation earlier this summer, Tammy talked with me about how voter suppression is a key issue that needs to be addressed head on if we really want to dismantle larger systems of oppression. People need to be able to vote and not be prevented from exercising their fundamental right to vote. Tammy suggested that the lab keeps its eye out on possibilities for ways to explore these issues, and here we are. So Tammy, Keith, and I have worked closely together on the creation of this project with a talented group of actors who you're about to see, our resident costume designer, Marion Talan, our video editor, Andy Wagner, and our colleagues at NYU TV, who have provided us with excellent guidance and support as we mounted our first virtual production, filming remotely in actors' homes. We're grateful for the support of all the sponsors that Lynn just mentioned, and we're also appreciative of the ongoing support we received from David Montgomery and the Program in Educational Theater, and also David Schroeder, the director of the Department of Music and Performing Arts here at Steinhardt. What you're about to experience is called You Can't Unring the Bell, and it's a series of 6 video clips that are verbatim performances of moments in history related to voting rights in America, starting in March of 1965 and continuing up until December of 2019. This is not a comprehensive moment-by-moment historical documentary like you might see on the History Channel, but rather we've selected moments that we've discovered through research that we feel provide different insights into the complicated issues of voting rights and voter suppression in this country. When we say verbatim performance, we mean word for word and gesture for gesture. The actors in each of these clips have studied scored transcripts along with audio and video recordings of the original people they portray, and they've worked to replicate those speech and gestural patterns as close to the original as possible. They speak the text entirely verbatim, including the original speaker's interruptions, pauses, and stumbles. These are not meant to be satire or comic sketches. Through our performed investigations of these individuals, we believe that we can learn something about their experiences by precisely replicating their speech and gestural patterns, and we believe that audiences can as well. Our work frequently includes playing across gender, race, ethnicity, and age as a way to investigate the experiences and experience what we think we understand in a different way. The performances are meant to spark conversation, dialogue, and reflection. To that end, given that this year is the centenary of the ratification of the 19th Amendment, we have cast women to perform some of the men in these original clips. In between each of the 6 short videos, Dean Knott and Professor Tolson will provide commentary and context for what you're about to see. And at the top of each video, you'll also hear some of the original speakers' voices so that you get a sense of who was speaking at the beginning of the clip. After the final video, we'll transition into a conversation and discussion, and we hope that you'll offer your thoughts and pose questions for consideration via the Zoom chat. As you experience these videos in the presentation, we ask you to keep the following question in mind. How does your experience of these people and their messages change when their words and gestures are delivered by different bodied actors? With that, I'm going to hand this off to Dean Knott and Professor Tolson to get us started, and thanks a lot for being here tonight.
Thank you so much, Joe. That was an excellent summary of what we're going to be doing tonight, and I'm really pleased that I can be joined by Franita Tolson from USC, where I just left about 2 months ago. Thank you for coming, Franita, and taking your time to be with us this evening.
Very thrilled to be here. Thank you.
So voter suppression really goes back to the founding of the country. It was in the original formation of the country, but this evening's event begins with something much more recent. But just keep in mind that the history is much longer. The event is going to begin with an exploration of voting rights in America in the 1960s, at the height of the civil rights movement. And while the Civil Rights Act of 1964 included a provision protecting voting rights, it was not as strong as President Lyndon Johnson had intended. And as a result, it really did very little to change attitudes and practices, especially in the American South. In his State of the Union address in January 1965, Johnson asked Congress to pass stronger legislation to end voter suppression, but Congress just couldn't do it. On March 7, 1965, Americans experienced what became known as Bloody Sunday in Selma, Alabama, as hundreds of civil rights activists, including Martin Luther King Jr. and John Lewis, were attacked by state troopers and sheriff's deputies as they attempted to cross the Pettus Bridge on their march from Selma to Montgomery. They were protesting the need for a voting rights bill. In response to these events, President Johnson called a joint session of Congress on March 15 and delivered a special message entitled The American Promise. In it, he called for Congress to act on passing legislation with far-reaching effects to end voter suppression in the United States. And so now we'll see Rachel Tuggle-Wharton perform an excerpt of Johnson's speech.
Extend the rights of citizenship to every citizen of this land. There is no constitutional issue here.
The command of the Constitution is plain. There is no moral issue. It is wrong, deadly wrong, to deny any of your fellow Americans the right to vote in this country. There is no issue of states' rights or national rights. There is only the struggle for human rights. I have not the slightest doubt what will be your answer. But the last time a president sent a civil rights bill to the Congress, it contained a provision to protect voting rights in federal elections. That civil rights bill was passed after 8 long months of debate. And when that bill came to my desk from the Congress for my signature, the heart of the voting provision had been eliminated. This time, on this issue, there must be no delay, or no hesitation, or no compromise with our purpose. We cannot, we must not refuse to protect the right of every American to vote in every election that he may desire to participate in. And we ought not, and we cannot, and we must not wait another 8 months before we get a bill. We have already waited 100 years and more, and the time for waiting is gone. So I ask you to join me in working long hours, nights, and weekends if necessary, to pass this bill. And I don't make that request lightly. For from the window where I sit with the problems of our country, I recognize that from outside this chamber is the outraged conscience of a nation, the grave concern of many nations, and the harsh judgment of history on our acts. But even if we pass this bill, the battle will not be over. What happened in Selma is part of a far larger movement which reaches into every section and state of America. It is the effort of American Negroes to secure for themselves the full blessings of American life. Their cause must be our cause too. Because it's not just Negroes, but really it's all of us who must overcome the crippling legacy of bigotry and injustice.
And we shall overcome.
Wow, Rachel, that was outstanding.
That was really
So,
amazing.
we only have a couple minutes here, Professor Tolson, so I'm going to just ask a kind of basic question, and that has to do with what were the implications of the Voting Rights Act of 1965, and did things really change quickly in the South?
No, it was transformative, to say the least. I would say that the Voting Rights Act is probably the most successful piece of civil rights legislation in our country's history. In the immediate aftermath of the signing of the act, turnout in the South skyrocketed. So in Mississippi, turnout was in the single digits, and by 1969, it had increased to 59%. 3 decades after the signing of the act, in some southern states where turnout hovered between 20 and 30%, you had turnout increase to the high 60s, low 70 percentile range. So, I mean, it had a transformative effect on not only voter turnout among African Americans and other minorities that have been historically disenfranchised, but also with respect to legislators. So you had more African American and Hispanic legislators than at any point since Reconstruction. So the act was very transformative and very important.
Yes, it's interesting that you mentioned Reconstruction because prior to the 1890s and into the 1900s, there was voting turnout in the South among Blacks that was in the 70-80% range. And many Blacks actually were elected to office. It was through these voter suppression laws that by 1910, you had these real low voter turnouts. And so it's this act and more or less almost worked to reverse what had happened during that era of Jim Crow laws.
Absolutely. And I'm really happy how you flagged the dates, because I think a lot of people think that Black turnout just dropped with the end of Reconstruction in 1877, but there were places where turnout remained high well into the 1890s. So the Voting Rights Act did have the effect of reversing a lot of that disenfranchisement.
Yes, that's why I'm glad you see it as such a dramatic turnaround, because the earlier period was such a dramatic turnaround in the opposite direction. And so there's very important parallels there, I think. So, all right, shall we go on to the next video?
Yes.
Okay, so the Voting Rights Act of 1965 was originally set to expire after only 5 years. But interestingly enough, it was renewed by Congress in 1970, 1975, 1982, and 2006. And even more interesting, in all 4 instances of its renewal, the updated legislation was signed into law by sitting Republican presidents, Nixon, Ford, Reagan, and Bush. And in 2010, Shelby County, partly because of this, in Alabama, sued the United States Attorney General and Federal District Court in Washington, D.C., seeking judgment that sections 4B and 5 of the Voting Rights Act were unconstitutional. The district court upheld the Voting Rights Act, so Shelby County filed a writ of certiorari with the Supreme Court, which heard the case on February 27, 2013, and then issued their 5-4 decision on June 25, 2013, striking down a key provision of the Voting Rights Act. We will now hear a section of Attorney General Eric Holder's statement in response to the ruling as performed by Susie Jane Hunt.
They continue to exist. Their effects are real. They are of today, not yesterday, and they corrode the foundations of our democracy.
Our country has changed for the better since 1965, but the destination that we seek has not yet been reached. Indeed, a reading of today's opinions demonstrates that every member of the Supreme Court agrees with this fact. As the Chief Justice wrote, and I quote again, "Voting discrimination still exists. No one doubts that," unquote. This is why protecting the fundamental right to vote for all Americans will remain one of the Justice Department's highest priorities. The Department of Justice will continue to carefully monitor jurisdictions around the country for voting changes that may hamper voting rights. Let me be very clear. We will not hesitate to take swift enforcement action using every legal tool that remains to us against any jurisdiction that seeks to take advantage of the Supreme Court's ruling by hindering eligible citizens' full and free exercise of the franchise. As the president has made clear, Congress needs to act to make sure that every American has equal access to the polls. The department also will work with Congress and other elected and community leaders to formulate potential legislative proposals to address voting rights discrimination. Because on their own, existing statutes cannot totally fill the void left by today's Supreme Court ruling. And I am hopeful that new protections can and will pass in this session of Congress. The Voting Rights Act has always had strong bipartisan support on Capitol Hill, and today's ruling should not change that. This is not a partisan issue. This is an American issue, because our democracy is founded on ensuring that every eligible citizen has access to the ballot box. Finally, we need to be clear about what happened today. Part of the Voting Rights Act, but not all of it, was struck down. The constitutionally protected voting rights of all Americans remain fully intact, and the right to vote, free from discrimination based on race and language, requires our vigilant protection. We know from many decades of long, hard struggle, the best way to defend a right is to go out and exercise it. So no one should conclude that today's unfortunate decision has rendered her or his voting rights invalid or has made attempting to cast a vote on Election Day futile. To the contrary, it is incumbent on all American citizens to stand up for their rights by registering to vote, by going to the ballot box, by exercising the most fundamental of all rights, and by voting for their preferred candidates of any party. Our democracy is dependent on each of us and on our active participation in the electoral process. Although today's decision represents a serious and unnecessary setback, the Justice Department remains committed to moving forward in a manner that's consistent with the arc of American history. which has always been a story of increasing equality, inclusion, and access to the franchise. This is what makes the United States of America truly exceptional. And this is what we will zealously guard.
Thank you.
Thank you, Susie. Again, what a great performance. Thank you very much. Professor Tolson, maybe we could just start out by trying to understand what provisions of the Voting Right Act were really called into question by this Shelby County v. Holder.
Unfortunately, it was the most successful portion of the Voting Rights Act that was called into question. So the preclearance provisions of Section 4B and 5 require certain jurisdictions, primarily in the South, but some jurisdictions out West, to preclear all changes to their voting laws with the federal government before those changes could go into effect. And these jurisdictions were selected in part because of their horrendous records on voting rights. They were, repeat offenders, constantly disenfranchising people, sometimes across the board. And so they were subject to the preclearance requirements. And because they couldn't make any changes without federal oversight, this made it very difficult for them to disenfranchise people. So in 2013, the Supreme Court struck down the coverage formula of the preclearance provisions because in the court's view, the formula hadn't been updated since the 1970s. So that meant that the jurisdictions that were covered based on outdated criteria. So poll taxes and literacy tests, which we no longer have. Even though those jurisdictions had a record of being sued more often under the Voting Rights Act than other jurisdictions, they still, post Shelby County, had sort of maintained their status as bad offenders. But the Supreme Court seemed to think that the federal government hadn't made the case that the coverage formula was constitutionally defensible because it was outdated.
So if it was a matter of outdating, is that something that could have been changed and looked at differently by the federal government itself without coming? Why wasn't it updated?
Good question. Congress does bear some responsibility for this. When the formula was renewed in 2006, Congress held hearings. They compiled a record that showed that the covered jurisdictions tended to still sort of engage in behavior that warranted continued oversight. However, they did not update the coverage formula. And it wasn't a secret. There were scholars who told Congress that it needed to be updated, that posed a constitutional problem.
And then what were the ramifications of this?
As you pointed out in your earlier comments, the Voting Rights Act had been renewed 3 other times, in addition to this time, and all under Republican presidents. And part of the reason that the coalition was able to hold together is by not disturbing the underlying legislation, right? So there were some concerns that you can open Pandora's box if you revisit the coverage formula and you basically make it possible that other states could be covered. And so to avoid all of that, they just renewed it as is.
Yeah, but you make a very important point there. I think that's kind of the key issue why it wasn't updated or anything like that.
Yes.
Because they were afraid that if they opened it up in some way, they wouldn't have that same consensus.
Right. Yeah, because it passed the Senate 98-0. There's no way that would have happened had they revisited the formula.
And unfortunately, Shelby was able to take advantage of that fact.
Yes.
Yeah. So, all right. We're going on to the next clip. So in June 2017, Stacey Abrams, a Democrat and former member of the Georgia State House of Representatives from 2007 to 2017, announced her campaign to become the first Black woman elected as the governor of any state in the United States. After winning the Democratic primary, Abrams faced Georgia's then sitting Secretary of State, Brian Kemp, as a Republican challenger in November 2018. After a highly publicized and contentious election that I remember very well, that included multiple allegations of voter suppression, Kemp became the governor of Georgia. And on November 16, in response to these election results, Stacey Abrams delivered a speech about the election process. Ashley Renee Thaxton Stevenson now performs an excerpt of Stacey Abrams' remarks.
Hello. On September 18th, thousands of Georgians began casting absentee ballots,
determined to lift their voices in the democratic process of electing our leaders for the next 2 years, the next 4 years. A few weeks later, more than 2 million Georgians declared their choices, heading to polling places for early votes. And then on November 6th, more than 1 million folks arrived in precincts around our beloved state, anxious and excited to express their patriotism through the fundamental act of voting. For these millions of Georgians, the act may have proven tedious and hard, but they had no doubts their votes would be counted. Certainly, there would be long lines and delays. Absolutely, a tired volunteer would mistype a name. And nature would not be ignored through rain or tornado warnings or chilly weather. We all understand the challenges and the complications. However, this year, more than 200 years into Georgia's democratic experiment, the state failed its voters. You see, despite a record high population in Georgia, more than 1 million citizens found their names stripped from the rolls by the Secretary of State, including a 92-year-old civil rights activist who had cast her ballot in the same neighborhood since 1968. Tens of thousands hung in limbo, rejected due to human error and a system of suppression that had already proven its bias. The remedy, they were told, was simply to show up. Only they, like thousands of others, found polling places shut down, understaffed, ill-equipped, or simply unable to serve its basic function for lack of a power cord. Students drove hours to hometowns to cast votes because mismanagement prevented absentee ballots from arriving on time. Parents stood in the fitful rain in 4-hour lines, watching as less fortunate voters had to abandon democracy in favor of keeping their jobs and collecting a paycheck. Eligible voters were denied ballots because poll workers didn't think they had enough paper to go around. Ballots were rejected by the handwriting police. Citizens tried to exercise their constitutional rights and were still denied the ability to elect their leaders. Under the watch of the now former Secretary of State, democracy failed Georgia. Georgians of every political party, every race, every region, again. You see, the incompetence and mismanagement we witnessed in this election had been on display months before in the Republican state legislative primary of Dan Gassaway. Counties, under the direction of the Secretary of State, issued flawed ballots, and not for the first time, and not just in that district. Only this time, the mistakes clearly altered the outcome. Representative Gassaway, a Republican in a heavily Republican district, had to go to court to force a fair fight. And therefore, on December 4th, tucked between the runoffs for Secretary of State and the Public Service Commission, for one community, there will be justice in the process. Win or lose, the people in his district will finally have a say. Many of the same Republicans cheered on Representative Gassaway when he filed his lawsuit. But the same ones have grumbled about the time we have taken to gain a remedy for fellow Georgians who faced a dizzying array of bad action, misinformation, and gut-wrenching hardship. But we are a mighty nation because embedded in our national experiment is the chance to fix what is broken, to call out what has faltered, and to demand fairness wherever it can be found. Which is why on election night, I declared that our fight to count every vote is not about me. It is about us. It is about the democracy that we share and our responsibility to preserve our way of life. Our democracy. Because voting is not a right for some.
It is a right for all, and it is not a privilege. I stand here today as witness to that truth. This election is about all of us, as is the resolution of this moment.
Wow. Again, thank you, Ashley. That was really outstanding. This seems to me a particularly egregious case, partly because Kemp was the Secretary of State. And typically the Secretary of State oversees the voting process. So it's an incredible conflict of interest that he was also running for governor. Do you see this then as being kind of such an egregious case that had some kind of impact on Congress and was kind of a spur, or was it just another example of what was happening in several states?
I think that is another example, even though I agree it is definitely egregious, right? And it offends the sensibilities. But I also want to reiterate that our system is one in which we allow the foxes to guard the hen house. And so it's kind of hard to frame it as being outside of our norms when our norms permit that. And to me, that's the shame. I do think that we would be better off if we acknowledge and confront some of the pathologies in our system that allows things like what happened in 2018 in Georgia to continue to happen. Because if you look at the primary in Georgia this past spring, some of the lines were 4, 5, 6 hours long. And so they have not gotten better since 2018, right? Things have just, in some ways, gotten worse, right? Because we've had 2 years since the midterms, 2 years since the gubernatorial election, and they did not take that as an opportunity to improve their infrastructure and to make sure that, as you know, Stacey Abrams points out, that everybody who is entitled to vote can vote.
Yeah, you know, this is something that's also going to be a big issue in the current election. I was trying to mail a letter the other day, and all the mailboxes are sealed off.
Yeah.
Around Washington Square in Manhattan. And it's a similar kind of situation in which you don't have enough polling stations, and there's going to be a lot of voting by mail because of COVID. So is that sort of reducing the number of polling stations, that kind of thing that was found there, is that always been there, or was that particularly important since the Shelby case?
So since Shelby County, it is a pretty standard voter suppression tactic to reduce the number of polling places. Across formerly covered jurisdictions, the number of polling places have decreased by approximately 20%. So it is much harder to vote. One thing I also want to point out, Dean Knott, is that we need to start thinking about voter suppression in these terms. I do think we are so accustomed to looking for the bad actor, right? We're looking for the Bull Connors of the world who spray people with hoses and sick dogs on people. But when people have to wait in line for 4, 5, and 6 hours, and when people can't find a polling place that's close to their home, or they have to travel long distances to get the required documents to get the ID that's free, even though the documents are not. Like, all of these things are voter suppressive because they make it more difficult to cast a ballot. They add to the cost of casting a ballot. And so I think we need to start thinking more along those lines. If we do, then I think folks will be more outraged about what happened in Georgia in 2018 and what happened in Georgia and Wisconsin and other states during the primaries this year. And they'll realize that this is a pattern. And in some ways, the fact that these things are happening within the framework of the law makes it even worse.
Now, is this the case, though, that the reduction in the number of polling places and so on is not uniform across the state, concentrated in certain areas, or?
It's concentrated in jurisdictions that used to be covered by the Voting Rights Act.
Yes. That needs to be emphasized, right? It's not
yes.
general, it's target.
Now, I don't want to make it seem like voter suppression doesn't happen in the North, right? It definitely happens in the North. But the Voting Rights Act, despite being outdated, did a pretty good job of capturing the worst offenders.
Okay, great. So let's go on to the next script. In the next clip, the Congressional Black Caucus has really led the way in developing a response to the Supreme Court's 2013 decision, specifically focusing on, quote, establishing new criteria for determining which states and political subdivisions must obtain pre-clearance before changes to voting practices in these areas may take effect. The Voting Rights Amendment Act of 2019, known as H.R. 4, was introduced in the House by Representative Terry Sewell of Alabama, and as part of that process, she testified before the House Judiciary Subcommittee on Constitution, Civil Rights, and Civil Liberties. Following her opening statement, Representative Sewell was questioned by the committee's chairman, Representative Cohen, and we'll now see a portion of their exchange as performed by Michael Scott Morales as Cohen and Andrea Ambam as Sewell.
Thank you, Representative Sewell. Let me ask you a question.
Mr. Johnson brought up some
harrowing
harrowing history in our country, where Republicans who had African American support were elected and threatened. These were in, I think, 1873.
Right, during Reconstruction.
Yeah. Do you know, in your experience as a student at Oxford and Princeton and Harvard, of instances in the last 40 years where similar incidents have occurred?
Yes, sir. I don't have to use my educational background. I can use my experience growing up in Selma, Alabama, and my experience as a member of Congress witnessing the changes that have been made in my own district. In my own district, people were denied the opportunity to get a driver's license after a restrictive law was passed by the state of Alabama's legislature. That restrictive law required certain IDs. An ID, we understand. Understanding, being able to say who you are is not a problem. It's the type of IDs. You know, my father, Coach Andrew Ray Sewell, in his latter years, had a massive stroke and was in a wheelchair. He proudly voted at every election. But after the 2013 decision in Shelby, and after Alabama imposed its restrictive photo ID law, which no longer allowed a validly issued federal ID, a social security card, to be presented to show proof of who you were in order to get your ballot, he had a hard time getting a photo ID. Well, not because he was Black, but because he was disabled. Do you know that the Dallas County Courthouse doesn't have a ramp that get people who are disabled into that courthouse in order to get a free photo ID from the voter registrar? And that is because it was grandfathered in the ADA law. So, sir, I have to tell you, my own personal experience, Dad woke up early that morning. We were blessed to have a van that kneels down so his wheelchair could go in. We were blessed to be able to have home help, to help him into that courthouse and to get that photo ID. So many of my constituents, and I would say all of our constituents who are disabled, may not have that same right.
Thank you, Ms. Sewell. And Dallas County, that's where John Lewis had his march, is it not? Where he was
That's right.
beaten on the Pettus Bridge to try to get the Voting Rights Act passed.
That's right. Not just John Lewis, but so many known and unknown Americans, Black and white, from various religious backgrounds, had the temerity, ordinary Americans, to really plead to this government that we live up to the constitutional ideals of democracy and justice for all. And while we live in a time where people don't have to count how many marbles are in a jar, I would submit to you that we still live in times where there are modern day barriers to voting. And as long as there are modern day barriers to voting, we as a Congress should be trying to institute and reinstate a coverage formula in Section 4. I would submit to you that mine in HR 4 is the right one. But I would also submit to you that all of us who see these injustices know that any formula that would allow preclearance where there's been a demonstrated history of voter discrimination in that state or subdivision would be merited.
And can you tell us if Mr. Collins and Mr. Johnson maybe as well mentioned Section 2 and Section 3, can you tell us why those are not sufficient?
Well, in the Calera case, the Shelby Counter versus Holder case, which was a case brought by an African American who was a city council member. He was the only Black city council member in Calera. When he was up for re-election, Calera, the city of Calera, voted to redistrict all of the districts for elections to city council to make it an at-large election. It's true he could have brought a Section 2 violation, but the reality is you can't unring the bell. He lost that election because the minority vote had been diluted by moving from a ward-based or district-based election to an at-large election. So I just have to say that, while on its face, even Alabama's efforts to close down the DMVs, I talked to my Republican governor, who was a good friend, and I said, what gives? 31 of those DMVs are in my district. And now you now have in place in 2014 this really more restrictive photo ID law. And he said, oh, it wasn't because of that. It was because of budgetary cuts. Now that on its face is true. But we as elected officials, when faced with the fact that the effect of it was limiting the opportunity of a certain population of people to having access to the most popular form of photo ID, a driver's license, we have to do the right thing. We have to do the right thing.
Thank you. And Mr. Johns, would you like any time? Thank you. We appreciate your appearance, and thank you for your sponsorship of the bill and your service as a colleague.
Great, thank you, Scott, and thank you, Andrea. That was wonderful. Thank you very much. Professor Tolson, you made reference to it's not just the South in your last comments when we were talking about targeting and so on. So could you say something, this is about their voter ID and what is acceptable. Presumably that's just not a Southern issue.
Oh no. So in the last, I would say even before Shelby County, you start to see more states pass restrictive photo ID law and also proof of citizenship requirements. And so the most recent sort of version of the photo ID laws is to only allow people to vote with a very narrow category of ID. So driver's license, passport, some places allow you to bring your hunting license, but you can't use a student ID, right? So it really depends. It varies by state. Other states are still, they are less restrictive. Another version of photo ID laws that are popular, well, not, I guess I shouldn't say popular. I would prefer if more states did this. If they're going to require ID, allow voters to fill out an affidavit if they have a reasonable impediment that prevented them from getting ID, and then they can still cast a ballot. So some states do have that as a safeguard of sorts. But this was in somewhat in response to Shelby County. You start to see states, particularly in the South, try to put in place more restrictive photo IDs. But the debate over photo ID laws started well before Shelby County. In 2008, there was a Supreme Court decision which found that voter ID laws are constitutional and did not violate the 14th Amendment.
So, requiring somebody to have a social security card seems a pretty strong
Some states allow that
requirement, right?
Right.
As opposed to saying you can have a hunting license or a student ID or things like that. Is that sort of extreme case of where you have to have some kind of documentation like that? Is that widespread, or is that limited to fairly small number of states?
I wouldn't say it's very small. It's definitely a healthy number of states that require you to have, something with your picture on it. But I will point out that for many people for which these laws are a burden, the problem is not necessarily the ID itself. I think most states can allow you to get an ID free of charge if you can't afford it. The problem is getting the underlying documentation. A lot of people don't have birth certificates. They don't have a passport, or they don't have naturalization papers or whatever they need in order to get the requisite ID. And that's difficult. Birth certificates can be expensive. In some states, they can be up to $40. Georgia, which we were just talking about, is $25 to get a birth certificate, and they charge you an $8 processing fee. So it's not always easy. And then people don't always live close to the place to get the ID, right? A lot of people don't have transportation, and they live more than 10 miles from the nearest ID issuing office that's open more than 2 days a week. So it's just very difficult.
Is this driven, do you think, also in part by anti-immigration kind of concern?
Oh yeah, the proof of citizenship laws are about anti-immigration, concern over non-citizen voting. But there's really no evidence that there's widespread non-citizen voting, just like there's really no evidence of widespread voter fraud that would justify restrictive photo ID laws.
Great. All right. Thank you. Let's go on to the next clip. So members of the House Judiciary Committee have continued to debate the proposed legislation to strengthen the Voting Rights Act, including debate around what constitutes a valid ID for voter registration. And as we heard Representative Sewell mention in the last piece, all sorts of obstructions, and as we've just discussed, have been used to prevent people from voting, and questioning the validity of certain kinds of IDs continues to be there to suppress the vote. In the following exchange between Chairman Jerry Nadler and two representatives from Louisiana, Democrat Cedric Richmond and Republican Mike Johnson, actors Scott Michael Morales, Darrell Cooper, and Daryl Embry will replay a conversation about different types of photo identification and whether or not they should be considered valid forms of ID.
In the City of Rome case, and I don't want this to get into a court argument about different citations, which we could go on all day with. In the City of Rome case, the court did find that discriminatory impact was sufficient under the Voting Rights Act pursuant to the 15th Amendment. I'll yield back now.
And who seeks recognition? Gentleman from Louisiana.
Well,
I didn't see anybody in this.
I was going to ask my colleague from Louisiana that basic question, that if your amendment gets on the bill, are you going to vote for the bill? Mike?
I would be much more inclined to vote for the bill, my friend, but I don't think you're going to pass my amendment, so it's a moot point.
Well, you never know. The second thing I would say is, and you talk about intentional discrimination, what your amendment addresses. I guess the question becomes, so let's say you're Texas or somebody and you pass voter ID that, school ID doesn't count, but a hunting license does count. Do we now have to go into the minds of the legislators if they all meet in the back room and decide that this is what they want to do because this is the effect of it? We need to go find intent? Or does the fact that it hurts the ability for African Americans to go to the polls, is that enough of a reason for you? Or do you need to know that the person did it with the intent to discriminate?
The gentleman yield to the gentleman.
I yield.
So I was a constitutional law litigator for about 20 years, and you were a great attorney as well. And in constitutional cases, they're very fact intensive, very fact specific. And I believe that's why the Supreme Court, in good faith, ruled that there has to be a determination on the facts. So if you had a scenario like the hypothetical is you're presenting, if they did that to suppress minority voting, it should be invalid. But you have to make a determination on that. And we can't allow the DOJ at the federal level with people that work here to make pronouncements about decisions at the local and state levels without digging into the facts. And that's all we're saying, because it's fairness. Ultimately, that's what drives all of us. We want fair elections. We believe in voting rights, but we have to have a determination of that, because that is the safeguard. That's the guardrail.
Will the gentleman yield?
I'll yield back.
I'll yield.
Thank you. I would ask, just following up from the question from the gentleman from Louisiana, on caught between two gentlemen from Louisiana. I'll ask the other one. We've seen situations where, such as the gentleman alluded to, where a voter ID law is required and college ID from state university is not permitted, but a hunting license is. Do you think, how would you, the obvious intent, it seems to me obvious, because you got a lot of minority people in university, but perhaps a smaller percentage having gun licenses, of the discriminatory effect. But you might not be able to prove discriminatory intent. How do you get in the minds of the legislature? The effect is obvious. I would think the intent is probably not obvious, but obvious, but not maybe legally obvious.
Well, can I respond?
Please.
So you might infer that, but we don't know the facts. And this is the point. I went to LSU, right? Back in my day, the student ID was the most easily fraudulent document. You can make a fake ID so easy from the LSU student ID. And people used to do it to get into games and stuff, right? That's different than a state-issued hunting license. In my state...
Would the gentleman yield for a second?
Wait, let me answer this. So I'm saying that it depends upon the facts. That's the point. We need a court of appropriate jurisdiction, someone who is an unbiased, objective reviewer of the facts to look at that. Is a student ID in that particular state as valid and as reliable as a hunting license? Well, then maybe there was some ill intent, but we don't know that on the face of it, and you and I don't know that in Washington, and that's why we need a court of appropriate jurisdiction to look at that, and that's the point. I yield back.
We yield back.
I'll reclaim my time. I would just offer that some things are so blatantly discriminatory on its face that I don't think intent matters. And let's assume when you were at LSU, I know you were all making fake IDs and going to the...
I did not say I was.
It's inferred now. And now that LSU is undefeated, I'm sure that you have a student ID.
Amen. Amen.
But part of it is the question becomes the hunting license. African Americans are very underrepresented in a hunting license. So the question becomes, why do you include a hunting license? One, at all. Two, a valid school ID from a public school. But the question is, why do you include the hunting ID? Why don't we just leave it at whatever the voter ID was? And I think that part of it is if something is blatantly discriminatory, the question is really about, do we then have to go prove the intent of the author of the legislation, which will always be some, good-natured excuse. And I think that is the biggest concern I have with the amendment, and the fact that if I put your amendment on the bill, you wouldn't vote for the bill, or you would be less likely to vote against it. It's probably not enough.
And with that, I yield back. Gentleman yields back. Gentlelady from Georgia. For our purposes, gentlelady, seek recognition.
Okay, thank you, Scott. Thank you, Durrell and Daryl. Really appreciate that exchange. Seemed very real.
It did.
I have to say. Let's maybe we could spend a couple minutes talking about what were the key updates of the VRA as proposed in the Voting Rights Amendment of 2019, so we get clear what that's about.
Yeah, so they were trying to, the House of Representatives was trying to get around the problem identified in the Shelby County decision about the fact that the coverage formula was out of date. And so what they did was they tried to come up with a formula that would be tied to current violations. And so basically a jurisdiction was subject to preclearance if it committed, I think, 15 or more voting rights violations in the last 25 years. So you get away from that problem of focusing on criteria from 1970 that deals with poll taxes and literacy tests that we no longer have. In addition, there's a known practices provision, which would prohibit certain practices known to be tied to, not prohibit, but subject to preclearance jurisdictions where they engage in practices such as closing poll places, which we talked about, but also if they redistrict after a huge demographic shift, or if they annex jurisdictions. So it's an entire list and the list is comprised based on actions by states over the last 50 years or so, and sometimes longer than that have traditionally been acts that have been engaged in order to shrink the electorate or disenfranchise African Americans. And it's nice because a lot of the things that states have done since 2013 have been upheld by courts, right? So the new Voting Rights Act preclearance provision sort of recognizes that these practices have a long history of suppressing the vote.
Thanks. One of the other little exchanges in there that we might have picked up is this point about the federal government trying to set uniform versus, the local context, local information. Could you say something about that dynamic in this regard as well?
So the idea of the federal government coming in and imposing uniform standards and not being responsive to local conditions, is this the people making IDs to go to the LSU football games? Whereas hunting licenses are more secure. I think that the response was the right one. Then why include the hunting licenses? Right? If you have concerns about ID, why include the hunting licenses when you know that there's a disparate impact, right? And also one thing that exchange sort of teased out as a bigger problem with proven intent, right? So to the extent that we're so focused on discriminatory intent and people being transparent about their desire to disenfranchise, then nothing will get accomplished. And so I think that's the exact right way to look at it, right? We have to question why states are taking the steps that they're taking. And if enough states are doing it, then that does demand a federal response.
But it also sounds like from the amendment that intent is not what is debated here. It's really, have you violated over a period of time, right?
Right. The intent question is often difficult, though, because Shelby County, the decision itself was focused a lot on the congressional record and the absence of discriminatory intent, right? Actions taken with discriminatory intent. There was some, certainly, but the court had hoped to see more. But intent is hard. It's hard to prove intent. And as that exchange shows, oftentimes actions are taken that have a discriminatory effect, which can be just as effective as actions taken with a discriminatory intent.
Exactly. So, okay, let's go on to our next clip. So Speaker of the House, Nancy Pelosi, called a press conference in the morning of the House's vote to pass H.R. 4. And she was joined by several members of Congress, including Representative Terry Sewell, whose testimony we heard before, as well as Representative John Lewis and House Majority Whip Representative Jim Clyburn of South Carolina. So our final clip of the evening features Representative Clyburn's remarks during that press conference as performed by Annalisa Gutierrez.
Stakeholders and I don't know what else to call these people. Hillary, I got some other names I'm going to call you, but thank you so much. I'm standing here thinking
back to my young days, and in 1966, my wife and I battled a driving rain from Charleston, South Carolina, going up to a little town of King Street that I proudly represent in this Congress today. We went there to hear Martin Luther King Jr. give one of his first speeches after the passage of the 1965 Voting Rights Act. It was a very rainy day. We were out in a cow pasture. I know it was a cow pasture. I saw evidence of it being a cow pasture. But we were there to hear Martin Luther King Jr. exalt, march to the ballot boxes. We in South Carolina had not done much marching to ballot boxes. I still remember my mother and father as young parents, young citizens, what they encountered trying to get the right to vote. We got it with the 1965 Voting Rights Act, and we have demonstrated it time and time again. But along the way, irrespective of the efforts of so many people, roads were not always made straight, as King exalted that day. There have been a lot of crooks in the roads, and one came about 6 years ago, when the Supreme Court took a look at the 1965 Voting Rights Act and decided that it was, for whatever reasons, outdated and needed to be made current. We took Justice Roberts' words to heart, and though we did not agree that it was outdated, we decided to do what we always do, and that is follow the law. of the Supreme Court of the United States. And thanks to the Speaker, we had 8 hearings by the Judiciary Committee, 9 by a special meeting that a leader of the Speaker created, headed by Marcia Fudge. They went around the country listening to people. And this bill is the result of those 17 hearings. And all the people here chimed in with their experiences and what they had developed. It's all now been wrapped into one piece of legislation that will be put on the floor in a few minutes, and we're going to pass it. So I want to say to Chief Justice Roberts and the Supreme Court, we listened, we heard, and we have acted in keeping with your instructions. And we call upon every member of the House, Democrat and Republican, to vote today to pass this bill. Every member of the Senate to pass this bill. And the President of the United States to sign it into law.
And with that, I'm pleased to yield to my longtime friend who I met in 1960. Never forget the weekend, October the 13th, 14th, 15th, 1960. The weekend before Martin Luther King Jr. went to jail for the first time. John and I were there together, urging King to go to jail to show us the way. A great compatriot and a real patriot, John Lewis.
Thank you so much, Annalisa, and thank you to all the other actors. These skits were so extremely well done and very moving. So thank you.
It was really amazing.
Yes, I love the playing out verbatim. It's just really quite remarkable. So thank you. The first question that has come in is, how have voter suppression tactics changed since 1965?
Right.
And getting at that a little bit, but maybe if we could discuss that a little more systematically.
Right. Yeah. So I think that in the 1960s, poll taxes were common, literacy tests, things that clearly had an impact on the electorate. Georgia is a great example of this. When they passed their poll tax in 1888, African-American turnout had been dropping throughout the 1880s, but it really dropped to like 4% by 1890. Like it had a huge impact. And I think you saw patterns like that all across the South. So that was going into 1965 in the Voting Rights Act. It was about poll taxes. It was about literacy tests. It was about intimidation and violence. It was election registrars who were very aggressive about disenfranchising African Americans and subjecting white voters to different standards so that they were able to register. So although we don't have poll taxes and literacy tests, I think it's important to understand that the goal of a poll tax or even a literacy test was to sort of replicate the racial and socioeconomic inequalities in order to replicate those fault lines. And so if you look at voter ID laws, if you look at proof of citizenship requirements, if you look at felon disenfranchisement, in many ways, these restrictions, although they're still legal, replicate the inequalities of the poll tax and the literacy test. And so states, they're using legal means to engage in many of the same suppressive effects that these earlier laws had. Felon disenfranchisement, for example, you see a lot of argument around reenfranchisement, where some states are reenfranchising felons, and that has turned into a huge political fight over whether they have to pay all their fines and fees, i.e. Florida, right? And so in some ways, this looks like you have to pay a fee in order to vote, right? This looks like a poll tax. Voter ID, you have to pay to get the underlying documents, right? There's always a cost involved. And this is all about raising the cost of voting, right? They make it prohibitively expensive to vote just in more indirect ways now than in the past.
Yeah, it's in some ways not so blatant. I mean, there's always these arguments for these kind of things, right? The budget, or things that on their surface have at least some point to them, but then have this hugely discriminatory effect. And that's
sometimes it is blatant.
What's so insidious about it, right?
Yeah.
It's on the surface, it sounds, well, we do want to know who's voting, and we do want to, we have to charge to get this because it's a cost, but then the cumulative effect of those is so negative.
Right. Yeah. Although, if you live in Texas or North Carolina, I like to call those two states the states that keep my election law class 3 credit hours instead of 2. Because they they just can't get it right. Those are the states where you are more likely to find discriminatory intent.
Okay. So then we had a second question, which has to do with, did any of the amendments deal with, and you made allusion to this earlier, with disability or access? Is that anything, is that something that's been included in any of the legislation or any of the thinking about this?
So I don't think that there's a provision in HR 4, which is the proposed coverage formula that deals with access for those who are disabled. But there is another bill. I think it's HR 1573 that would amend the Help America Vote Act to deal with issues of accessibility. I don't think it's made it out of the House, though. I think it's still in committee.
Okay, so that really hasn't gotten into any.
No, it hasn't gotten as far as HR 4.
Yeah. So we've got a couple questions also on what can we do as individuals to try to fight voter suppression. If we really believe this is a important issue, what can we do?
I hate myself for what I'm about to say because it frustrates me to no end. But you have to stay in line. You have to vote. You have to have a plan. You got to have a plan for election day. Because we're in the middle of a global pandemic and people are voting by mail at numbers that a lot of states might not have the infrastructure to accommodate. So it's very important to have a plan. Vote early in person if you can. If you're mailing in your ballot, do it early. Because honestly, it's very difficult to challenge voter suppression. As I mentioned, a lot of the voter suppression is happening within a framework in which a lot of these tactics are legal. And so, you have campaigns that are suing to sort of challenge some of this, but for individual voters, it's really important to, make sure you vote. And I'm also a fan of political activism. You can vote, you can march, you can speak out, you can write op-eds. These are things that there's no special qualification for this. If this is something that you feel passionate about, I really think that the public has to be more coordinated in pushing back against this. And that involves having political activism on a number of fronts. So, November, I think, is going to be frustrating. It just is, right? It's going to be a pain to vote, and you just have to do it anyway. But there are other things you can do. You can march, you can speak out, you can wage social media campaigns, anything to keep this issue live, because I do think we tend to forget about voter suppression from one election to the next. And then the next election, we find ourselves in the same boat. So another important thing here is visibility, right? Keep this on everyone's radar so that when we vote again in 2022, or for those of you who have local elections next year, 2021, we're not dealing with these same issues. This is something we have to continuously fight.
Good. You made reference to November. One of the questions that has come up in the chat is, what is the greatest threat to the upcoming election as you would see it in terms of voting?
The answer is obviously the president. I can't think of any PC way to say that. I'm sorry. I feel like he hurts his own voters too, right? Discouraging people from voting by mail when there's no evidence of widespread fraud is terrible, right? Because these are a lot of people who need to vote by mail, right? It's bad for the system. It calls into question the integrity of the election. It causes people to question the legitimacy, absent any evidence that it's illegitimate. It's just, I think it's going to cause huge complications. And so maybe I should, to be more PC, I'll say the president's Twitter account. That sounds better.
And one of the keys here, of course, is the pandemic.
Mm-hmm.
People are not going to want to stand in crowded lines for 3 hours. And so they're going a larger proportion, and everybody's predicting this, people are going to vote by mail,
mm-hmm.
way more than before. And so the difficulty of doing that, or the questioning of whether it's legitimate, or if there's more voter fraud by mail versus in person, these are all the kind of key issues. And I would also think that, like in past presidential elections, it tends to come down to a very small number of states that are so evenly divided that the number of votes between one side and the other is a small number.
Right.
And what we're going to find in this election is that that's going to even be more complicated than past ones because of the large number of mail-in ballots. So we're not going to find out in the first day or two how that margin is going to play out.
Although, Dean, I do want to point out, to be fair to election administrators, they are trying, right? Like they really are trying to accommodate what is turning into a pretty unprecedented situation. One thing I find is that when you get down to local election officials, they just want to get it right? They're not, when we talk about partisan politics, we're really talking about Secretary of State, we're talking about presidents, we're talking about, people running for office, Congress. These are the people who tend to infuse politics. Local election officials just want to get it right? So you do see them trying to figure out ways to be more accommodating and work with state officials in order to make sure that people who want to vote can. And I think that's important because, we focus so much on the politics. I think what gets lost is that you really do have people working on the ground trying to get it right. But you make a good point about certain states and the election being close. One state I'm keeping my eye on is Pennsylvania.
Yeah.
Pennsylvania has been on my mind a lot this week. And I'm really worried that, election night, Pennsylvania is still undecided and the race comes down to Pennsylvania. There's been a lot of litigation there about absentee ballots. And, it's sort of turning into the poster child of everything that election scholars are worried about with respect to this election. So we'll see.
Yeah, no, I agree with you completely. I've had over years experience with the local election officials. Mm-hmm. They're pretty dedicated.
Yeah.
They just want to make it all work. They're not as partisan as the politicians themselves, and they're going to work as hard as they can. But given the volume of mail-in ballots and the tightness of the election, Pennsylvania is going to be
right. But I do think it's important for us to distinguish, election administrative errors, which will happen, right? Because we're dealing with, millions of votes from, fraud or a rigged election or whatever. Like there will be mistakes. There's mistakes every election. Even in local elections, there are mistakes, right? And so I just think that the public has to be patient and understand that we have to give the people time to count the ballots and make sure that we come to an outcome. And I think that might be hard for us because we're so used to knowing on election night who the winner is.
Yes, and now we also have a couple of questions, in some other countries like I think Italy and Australia, people are fined if they don't vote. It's a requirement. Some countries, they set aside voting day as a holiday. So could you say something about that? If we made election day a holiday, would that be a good thing? And would you?
I think that would be a great thing. I cancel class on election day. So, I am committed. I am in it. I will do a makeup class so that my students don't have to come to class on election day. I think it's very important because it is a better recognition of our reality, right? People have to go to work. People don't have childcare. And so you really do, we live in a system where we put the burden on the voter to figure it out, which is inconsistent with our language about voting being a fundamental right. how is it a fundamental right when we make it so hard to do it and we try so hard to take it away from people? And so Election Day, making that a holiday is a step in the direction of making sure that voting really is a fundamental right, and we're making it easier for people to vote.
Okay, so I'm going to go to this question next because it's about Ruth Bader Ginsburg, and that's obviously very timely here.
Yes.
And so how will a potential replacement for RBG discount the hoped for effects and outcomes of a new president if a new one is elected? I also want to read a quote. This goes back to the Shelby County versus the Holder in a case in which Justice Ginsburg wrote the dissenting opinion and the 5-4 opinion.
Mm-hmm.
And she wrote, quote, throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet.
Right.
So what do you predict?
Yeah, so the pre-clearance provisions of Section 4B and 5 were unique in the sense that the success of the pre-clearance provisions in preventing discrimination created a record that the provisions were no longer needed. Right? Like it's the most ironic and perverse outcome that one can have, right? The success was actually used against pre-clearance in court. And it just seems really weird because the entire regime was premised on this idea of preemptively preventing states from taking steps to disenfranchise people. Now all we're left with is, and I don't want to minimize Section 2 of the Voting Rights Act, it's still very important, right? But now states can violate rights and then you have to sue them, right? And then we have many of the states violating rights who were covered by pre-clearance and they would have been prevented from doing that, right? So it was very successful, but its success ultimately was used against it. I think that a replacement for Justice Ginsburg won't do anything to improve the court's position on voting rights. If you look at some of the decisions that have come down in the midst of the pandemic, the court has been very hostile to pro voting rights, right? They have not been a friend of voting rights at all. And I don't anticipate that a new justice will take a different position. Instead of it being, 5-4, it'll be 6-3.
Yes, that's the likely outcome, I think. Going back to something that we were discussing a minute ago, we got a couple more questions about which states won't have a result on election day. They refer, for example, to Michigan Secretary of State, who said that they would not have results on election day. What other states are you thinking would be in that situation?
So some states don't allow counting to begin until election day. So even though they have early voting and people are mailing in their ballots, so there are states like that. But in terms of like pivotal states, so Pennsylvania is one where I don't expect that there'll be results election night. States that were pivotal in 2016 will probably be hesitant as well to declare a winner unless they're sure. Right, like I know that would be my position.
Yeah. Right.
So Michigan,
media, maybe too, right? More.
Huh?
News media is pretty quick.
Oh yeah.
To try to project, but in this particular election, it may be harder for them to.
I'm not entirely confident about the media yet, right? Like the Iowa caucuses, I don't know. January seems like it was a lifetime ago, but the controversy around the Iowa caucus and how. There was some malfeasance on the part of the Iowa Democratic Party, but they were also trying to make sure that they had counted everything properly. And so we sort of conflated the malfeasance with, the delay, and we inferred that something nefarious was going on, right? And that was, that wasn't the entire story. So I'm a little worried about the media, about what will happen in November. We'll see. I do think that they have learned some lessons from 2016. So I'm definitely optimistic. But I do think that in certain states that were key to the president's electoral college victory in 2016, there probably will be some hesitation to call the race quick unless they're absolutely sure. And probably in other swing states as well. But The upside is that I think most states we will know, right? Most states we will know. The problem is that it's just the states that we won't know actually matter to the outcome.
we're going to know New York, and we're going to
right. We're going to know California.
We already know New York and California,
right, which is entirely unhelpful. But what can you do?
No, exactly. What is happening with this bill, the amendment bill?
Oh yeah, so it passed the House.
What's happening?
Yeah, so it passed the House. It's in the Senate now. It will not pass the Senate unless the Senate switches to Democratic hands. It's there.
So unless there's a real political change in this election, we're unlikely to get any new amendments to the Voting Rights Act.
Right. Although, so let me put a positive spin on it though, right? You know, this HR 4 has been tossed around in some form since Shelby County, right? So the conversations about how do we update the coverage formula, what can we do that's constitutional and consistent with the court's opinion? These are questions that election law scholars, the advocacy community, we've all been in conversations about this for years, right? So even if we have to wait a little while longer, it just feels good to have a bill out there, right? And to, you know, try to convince the public and show the public the need for the bill. So I'm not disheartened by the fact that it hasn't passed the Senate yet. And even if Mitch McConnell remains majority leader and it remains, you know, I'm like, okay, we'll try again in 2 years, right? The fight has always been a long one.
It's definitely been a long one and a frustrating one, and one that's, you know, 2 steps forward, 1 step back, or sometimes 2 steps back, right?
Yeah.
So yeah.
You have to have a piece about that doing this type of work.
I know you have a hard stop, so I want to ask you this last question. And then other than vote, what is one thing we should take away from this program as an action item?
So voting is not something that exists in a silo, right? I think we have to think about political participation very broadly. And we also have to think about voting broadly too, for that matter. So let me start there and then branch out, because voting, people are like, well, it's a presidential election year, let me go vote for president. There are down ballot races. There are local races. There are, in some states, there are ballot initiatives, right? So voting entails, you know, voting for more than just the president. It's also important to vote in off-year elections. It's also to vote in local elections. We need to have a culture of voting, right? Not just, you know, every 4 years, everyone pays attention. We need to consistently pay attention. And so that's why we have to branch out beyond voting. We're living in a time where Black Lives Matter protests are at the forefront. We need to keep that energy, right? And and that requires more than voting. That requires marching. That requires, as I mentioned before, writing op-eds, social media, pushing out messages, keeping these issues in everyone's consciousness so that it doesn't fade away when the election is passed. That's been the problem. Think back to 2012. We got a commission to study our system of elections, right? We always get a commission. We love commissions. And then nothing happens, right? The new president is installed, or the existing president goes into his next term. We study the issue and then we move on. Let's not move on. Right? The promise to ourselves after this year has to be that we will not move on, right? Because our system is fundamentally broken. The fact that we have to have conversations about rhetoric and whether or not the election is legitimate just because people don't know who won on election night, you know, it's just, this is a bizarre place to be. We're so used to dysfunction. Our baseline is dysfunction, right? The fact that the presidential election, the president represents all 50 states and territories, yet it comes down to Pennsylvania. My fate turns on Pennsylvania, right? No, the system is broken, right? And so it's really important for us to continue this conversation moving forward, and that does require more than voting.
Absolutely. So I think it's just about 8 o'clock, and I know Professor Tolson, you have to leave. And I'm really so pleased that you are able to join us this evening and give us this commentary.
Yeah, it was really great. I have to say the performances were amazing.
They really were. And I want to thank all the actors and the people who produced it. They did it, you know, it makes it real for all of us. And it was an amazing performance. So thank you all very much. And we hope that we can engage you again in the future.
Absolutely. Thank you so much.
And thanks to the audience. I can't see any of you, but thank you for your wonderful questions. Thank you for participating. And there will be other events on this issue of voting, and please participate in those as well. So thanks, everyone.
Take care.